Welcome on the second stage of the selection to the HQCJ, Viktor. Good morning. So the selection commission is conducting this interview in its full composition. Robert Brugheisen, me, Ivan Mishenko, Sergei Verlanov, Yevhen Mezentsev, Tadzachny, and Steven Markman. The reporters at your interview are Robert Brugheisen and me. If for any reason our interview is interrupted, we will continue it at some other time on the other day, and we will reschedule it together with you. During the interview, you will be asked questions. We would ask you to give concise, clear answers to the core of the matter, and then the commissioner asking questions shall be entitled to limit the time of your answer. This is caused by the fact that, unfortunately, the time for the interview is limited. Before we start the very interview, you will have a chance to tell about your motivation, about your ideas, about the functioning of the new HQCJ, or about the future of the judiciary in general. You choose. With this, let me give the floor to my colleague Robert.
Good morning. I'm the rapporteur on your file with us, and we would appreciate if you would take 5 minutes to introduce yourself and to explain to us and everybody who's watching who you are, what your background is, and why you have applied for this important job.
Thank you. I'm Viktor Smorodynskyi. I'm 57 years old. I'm associate professor of the National Law University named after Yaroslav Mudry. All my achievements, or most of my achievements, are mentioned in the CV and the motivation letter, and I would just like to tell that for 25 years, and this is in fact half of my conscious life, I've been dealing in my scientific activity with the issues and problems of the independent judiciary, judicial reform. I've got some achievements in this respect. I am the author of the PhD, and the topic is the judiciary, and the second section of the PhD is dedicated to the judge as the central figure in the judiciary. The third section is dedicated to judicial reform, and I'm not ashamed of what I wrote in my PhD, so now I would change a lot of things because of my experience. I'm the co-author of the first joint monograph on justice in Ukraine, and together with Professor Markotsvik, who was my lecturer, my teacher, I wrote a lot of articles on the judiciary. I'm the author of a lot of other scientific papers. I'm the trainer and the co-author of the practical course on the rule of law. And the participants, the trainees within that course, were in particular judges of the Supreme Court, the High Anti-Corruption Court. And one of the graduates is the new chairperson of the High Anti-Corruption Court, the chief judge of that court. And I'm also the head of the Commission on Academic Integrity of the National Law Academy, named after Yaroslav Mudry. I've been holding this position for 3 cadences, 3 terms. I've been elected to this position by the members with no influence on the part of administration. I'm a member of a lot of NGOs. Participant of the civil society. I'm active, and I understand how important civil society is for the state activity and for the judicial reform. But along with that, I've always seen that a lot of my ideas are somehow not brought into reality. Well, some of them are, but a lot of them are not implemented, are not brought into life. And it was in 2015 that at one of the highly important events, where all the top leaders of the judiciary participated, during one of the informal talks, I was approached by a representative of our donors from the UK, and he told a very important thing for me. I tend to memorize this and to recall this statement, and I share it with my students all the time. He said, I don't understand why we have introduced the same program at the same time in several countries, and I'm now looking at the situation. Everybody claims that everything is fine, but we are starting the reform from scratch. And we seem to be having the reform, but from my point of view, nothing is happening, or what is happening is very slow. And he told me, aren't you ashamed? And that was nothing new. And I'm not telling just to you. I used to tell this to my students. I really felt ashamed. And that was a kind of a turning point in my life, 2015. And that's why I decided to participate in the practical implementation of the ideas I had been advocating and studying for 20 years. And in 2016, I participated in the selection for the position of the judge of the Supreme Court that was conducted by the previous composition of the HQCJ. And I got quite a good score. It was 812. I was recognized to be the person who has confirmed his capacity to administer justice in the cassation commercial court. But I took the 37th place out of, actually, when the passing score was like 30 places. And I can see that the people who've been selected to the court, real cassation court, are really great. So I'm anyway proud of being ranked almost side by side with them. But again, the reform is slow even now. That's why I would like to accelerate it, and I would like to participate in this process. So thank you for this opportunity provided to me, because through this fresh breath, new oxygen, we can actually introduce the reform. We should fill the lungs of the judiciary with this new oxygen, the way this happened, for example, to the Supreme Court. We should do the same with trial courts and appellate courts. This is my main motive. This feeling ashamed, that is the feeling I would like to transform into the feeling of my pride. That's it. Thank you for attention.
Well, thank you, Mr. Smorodynskyi. When I read your motivation letter, I can see that you have lots of experience in judicial reform, that you thought apparently a lot about that. You just explained to us, and I also read this in the motivation letter, that you devoted your life to the study of problems of the judiciary. And then you explain in the letter what you think that has to be done. And you say in the letter that there are three things that you think need to be done to change the judiciary as a first thought, as your vision. The first one is the 2,500 judicial vacancies. And you explain, of course, that they need to be filled, and it gives an enormous difficulty that there are not enough judges. And secondly, you refer to the unlawful decisions of those semi-states in the East. And the third one, you say, is that your country has no alternative to the prospect of joining the European Union, which requires today creating a judiciary that will be able to perceive, systematically interpret and apply the rules and principles of the EU law. You know what I find very special, that if you devoted your life to studying the judiciary, and I must say I see this often, that I see many great words in the motivation letter, and people also explain the words time after time on the screen. Independence, decent, transparency, all those words. And when I hear this word, I'm thinking sometimes of when I gave some courses to banks about money laundering, where also many people would say that money laundering they're not able to explain what money laundering is. But what they think it is a ticking of the box exercise. If you have a form where you're ticking some boxes and you have done that, then there is no money laundering. And that's what I see here as well. Because when I read your letter, I do not see anything that discusses, in my view, the real problem, and that is the fact that there is quite substantial corruption, or in any case, that the public thinks there is corruption, the donors think there is corruption. Why don't you not address this elephant in the room? Especially because, of course, you would know it exists because you devoted your life in studying the judiciary.
Thank you for the question, Mr. Lawyer. Definitely, we do have corruption. We not just have corruption, we have constant, regular pressure on the judiciary on the part of executive authorities. That is really true. And that's why I think that the core element, the core reformer of the judiciary is a judge. It is a judge who should have what I call positive and negative integrity. Positive and negative attitude to impossibility of having corruption in place. By negative and positive attitude and treatment, I mean the analogy to positive and negative commitments of the state in the field of human rights. By negative, I mean that the judge himself realizes that it's impossible for him to take corrupt actions. And positive integrity lies in the fact that a judge has zero tolerance to non-integrity, lack of integrity as manifested by his colleagues. And I even made a report on this problem. I had a 45-minute report, a rather long report on that speech. And I think that this element of positive integrity is most important. I mean, when you as a judge has zero tolerance to any unethical manifestations of lack of integrity by his colleagues in the neighboring courtrooms and by other members of the judicial corporation, if we may call it like this. And I think that this positive attitude, positive integrity is even more important because, to check a judge whether he is a man of integrity is not such a difficult thing to do. You have documents, you have his previous life and career, and you have some evidence. But to check whether the judge has got this zero tolerance to lack of integrity in other people is a much more difficult thing to do. It's not enough to have documents and facts, but it really requires a regular communication with this judge. And that's why we have interviews, and that's why even the person who is doing the selection, who is doing the inspection, should be guided sometimes even by his or her intuition. Intuition which is based on professional, general human experience of this process, who is making the selection, who is doing the examination. And when we have got this critical mass of judges with this positive integrity, zero tolerance to corruption, which means that I don't take bribes, but that's not enough. You should also be taking active steps for the bribes not to be taken by other colleagues from the judiciary. That is what we call the reputation, not your own reputation of a man of integrity, a judge of integrity, but the reputation of the whole judiciary. And only all these elements together will be kind of safeguards against lack of integrity in courts and corruption in courts. That's what I've been telling a number of times. This is what I believe.
Well, thank you. But then I will take it a bit further. I hear this, what you say, or I've heard this many times now in the interviews we have done. And if I think about it, I often heard the word zero tolerance to corruption. So anyone on the screen says that. The point is that when I think about it, and I've been doing that a lot of all those days, looking at the screen. It is not about only have a zero tolerance to corruption, but also that you show that the judiciary is incorrupt. It's not only about justice to be done, but also justice to be seen to be done. But if you want to increase trust in the judiciary, the first thing that should happen is that the people of Ukraine believe that the judiciary is independent, not incorrupt, and will deliver good judgments. And what I see from the candidates that pass by, that many of them, they show quite enormous wealth. They drive in very big cars to the court. And my question is to you, if you want to enhance trust in the judiciary, is it a good idea that judges, all of them, they drive to court in a Mercedes or an Audi that costs $150,000 while you are in a high office? And that maybe the people who seek justice and come to the court come in an old Russian car of 25 years old.
Thank you, Robert, for your question. I'm not going to tell anything new, but the guidance here is the Bangalore principles. And one of the criteria there is the decency criteria, appropriateness criteria, which means that the judges and the judiciary should not just pass their decisions in a decent and appropriate way, including on the basis of impartiality and independence, but their whole conduct should be appropriate to the outside. It should be perceived as such. And from this point of view, I would agree with you that really there are some things that need to be changed because, well, everybody understands that the remuneration of judges is rather high, and it's substantiated from the point of view of judicial independence. We know that one of the safeguards, and this was said by Alexander Hamilton in his Federalist Papers, that one of the guarantees, one of the safeguards for proper work of judges is adequate financial remuneration of judges. But at the same time, for some reason, people forget that one of the three safeguards of independence is trust in the society. Trust in the judiciary by the society. And an element of this trust comes from the understanding of the society of the fact that judges behave in an appropriate way. That's why I think that even high judicial remuneration does not yet constitute the reason for judges to show this high remuneration, in particular in the current conditions where we are facing an economic crisis for the state and for people in general. It's not appropriate for them to show this evident disproportion between their way of living and the way of living of the whole society, of all other citizens, because judges are a part of this society, and judges are not located in some isolation from the whole society, and they should be fully aware of that all the time. And the ivory tower, well, this is not my metaphor, but the former chief judge of the Supreme Court of Israel told about this ivory tower, so I agree with him and his ideas. Thank you.
So when you are elected in the HQCJ, you're not going to use the Audi e-tron of your wife to drive to court, because I believe that this car costs a fortune.
Well, thank you for the question. My wife has just the e-car, and she bought her car with her own money, and I drive Volkswagen, which is 9 years old, and it's absolutely enough for me. So what will definitely not happen, and I think that this is right, that during my term, suppose I get this honor of being elected a member of the HQCJ, I will not replace this car with any other one. I will just be driving my car.
And you think that it is sufficient that you have a professor who has a wife who drives a very expensive car and has apparently quite a lot of wealth? I also see that you have personal cash of quite a substantial amount. That this is that you drive in your older Volkswagen to your work sufficient to enhance trust?
Thank you for the question. Well, I think that we have equality of husband and wife in the family, and if my wife decided to buy an e-car, Audi e-tron, at the price which is equivalent to $53,000, well, this is okay. It's not a luxury car, and the guidance here is even the order of the Ministry of Finance, that determines 230 cars that are luxury cars, and that should for which the higher taxes should be paid by. But my car is not included into those 230 cars, and the $53,000 is the price which she could actually afford, and she thinks that this is okay.
Okay.
Well, now a new middle-class car costs about the same amount of money in car saloons. It's not just Audi class, but just she bought it abroad. That's why it was cheaper for her. But I don't drive this car, and I'm not going to be driving it. I got my own car.
Well, I learned something. I didn't know that the Audi e-tron was not an expensive car. It looks expensive, I can tell you that. I pass the floor to my co-rapporteur, Ivan.
Пане Вікторе, скажіть, будь ласка,
Victor,
правнича фірма Еверест,
the law firm Everest you founded and you are the head of,
яких клієнтів вона супроводжує?
what clients do you have? What kind of projects do you have? Thank you for the question, Your Honor. I'm not the head of this firm. Well, I stopped being the head of this firm in 2009. My wife is the head of this law firm. I'm the co-founder of this firm. This is not the company that is carrying out any activity. It's just a formal entity which exists. It's just a formal project which we... And of course, if I'm elected a member of the High Qualification Commission of Ukraine, we will close this firm. We have not been dealing with it. We haven't had any activity in this company over the recent years. It was an actively functioning company until 2004, and after I started being an academician, a scientist, I came to like scientific activity much more. So formally, I was the head of this law firm until 2009, and this is indicated in the documents I've submitted to the commission, but that was just formally. So actually, it stopped operation in 2004. Then let me clarify a couple of things. You claim that this firm stopped its operation in 2004, but during your interview to within the High Qualification Commission during the selection to the Supreme Court, you claimed to the question about your property that the sources of income of your income is sales of the apartment and income of the law firm Everest over the period of 1999-2012. So please do help me to get clear about this. Is the information unreliable or what? Thank you for the question, Your Honor. The problem is, and that was actually generally known, that when I participated in the selection, I was trying to provide all financial documents, and I really submitted all the financial documents, and there were no questions concerning my property and the correlation between my income and costs of mine and of my family. And that's why, to tell the truth, I didn't expect a question like this from the selection commission. And I was at a loss at that interview, and I started recalling all the things that had happened over that period of time, because of course our savings or our income were not the result of 1 year. That's why I mentioned the law firm. But then I got myself clear about that, and I provided all the confirming documents and all the calculations, in particular as of 2015, in order to confirm that all the purchases, all the savings of our family fully correspond to the level of income of the family. And when I was explaining this to the commission at that interview, they understood that I was just at a loss because I didn't expect a question, and they decided to confirm my ability to administer justice in the cassation commercial court. I think that they understood that that was just the reason. Well, the reason for that was just psychological loss. I just tried to recall whatever had happened during my life when I generally earned any money. Okay, clear. We do have the data that in 2019, during the election of the president of Ukraine, you were official observer from the candidate Anatoly Gritsenko. Is it true? Yes, it's true, Your Honor. And I have already submitted written explanations to the Commission on that matter. Yes, please do tell us the role of the official observer of one of their presidential candidates. Is it not a kind of a sign showing that you are politically engaged? Thank you for the question, Your Honor. I think that there is no political engagement on my part. I was offered the position of the official observer of the pro-ruling candidate, but I didn't agree. I became the official observer of the candidate who was known not to ever become the president of Ukraine. And I represented this candidate for 1 day. I was his official observer for 1 day. I never had any propaganda in favor of that candidate. I never participated in the election campaign of this candidate. I just took this chance as an opportunity to see from the inside at the election process and to participate in it. And I'm satisfied with this because I made my own contribution. Then I wrote some complaints, by the way, and I saw some complaints that were satisfied. I mean, complaints against the actions of the election commission. Unfortunately, the law on the election of the president of Ukraine does not contain any opportunity to see the system from the inside otherwise, to see the legality or legitimacy of the election otherwise than to be a member of a certain party, of a certain candidate. And even the members of the election commission should necessarily represent a certain candidate. So that was my chance, and I decided to use it in order to see the system from the inside. It was interesting for me as for a scientist and representative of the civil society. Thank you for the answers. Let me give the floor to Stephen Markman. You're welcome, Stephen.
Thank you, Mr. Chairman. And thank you, Professor Smorodynskyi, for participating in the competition. I have a question about that official observer matter as well. That was part of 8 questions that you were sent, and you acknowledged that you had not answered that question in a way that might have been satisfactory to everyone. If this commission were hard fixed to the idea of a zero-tolerance standard, would you have passed muster? Would we have moved you forward in this competition as we did? We hear that, as Mr. Brookhuizen has indicated, we hear that standard all the time, zero tolerance. If there'd been a zero tolerance standard, would you have been moved on in the competition in light of your answer to whether you'd ever been an official, whether you'd ever participated in a political or a partisan matter?
Thank you for the question, Your Honor. From my point of view, as far as this specific question is concerned, because I don't know what your standpoint concerning other issues related to me are, but as far as zero tolerance is concerned, I think that I'm really clean. I'm clean even in my thoughts, not only in my actions. And the fact that I was an official observer for one day, and I represented not the pro-ruling candidate, and I did not participate in any election campaign of this candidate. I did not in any way promote this candidate to the high position of the president of Ukraine. And I think that this shows that this activity of mine is not related to political engagement and political activity. It was motivated and urged by the pure wish to do something good for the election system in general and not for this candidate. And, well, I, of course, cannot assess your standpoint, and you're being fixed on a certain principle standard, but I respect it.
My standpoint is that your answer was fine, and my standpoint is that there is no integrity problem that's raised by that. But the fact is, there are good and reasonable people who might have looked at your answer and thought that it was an imperfect answer to the fairly straightforward question concerning your political history.
Well, I have given an honest answer, and the way the people perceive this answer, well, I cannot actually affect this. I think that there are like-minded people for me in civil society. There are my university colleagues and my friends, and I'm sure that they do understand that I am an honest, I've given an honest answer. That's everything I could do in this respect. Thank you.
Professor, tell me, what are you going to do to transform your sense of embarrassment over aspects of the Ukrainian judiciary to pride? What are you looking at as some of your priorities in achieving that transformation? You must have thought about some of these issues. You talk about brainstorming, but what are you going to do to achieve that very significant and important transformation for your country?
Thank you for the question, Your Honor. So, first of all, suppose I am elected a member of the High Qualification Commission of Judges. I will, first of all, initiate amending the rules, selection rules for the candidates. I don't know whether these are going to be new rules or just amended applicable rules, because the applicable rules contain quite a lot of good things, and that's why we can see some good outcomes. First of all, election of a very effective Supreme Court composition we can be proud of, high anti-corruption court we can be proud of. So what else needs to be done, as I think? First of all, we should remove conflicts between the High Qualification Commission of Judges of Ukraine and the Public Integrity Council already at the selection stage. We definitely do have this conflict, and the results are very negative. The results have affected the legitimacy of both the High Qualification Commission of Judges and the results of the, well, not the results, but the activity, the results from the point of view of the society. I think that what we can do to resolve this conflict between the official representative of the civil society and the HQCJ, should be removed from Articles 87, 88 of the law on the judiciary status of judges. And I think that we should change these articles. I'm a member of the one of the task forces affiliated with the Speaker of the Verkhovna Rada, and I know that cannot be changed overnight, but we can change it on the level of bylaws to make the relationship between civil society, the contact between the civil society and its representatives, and the body which is a comprehensive representative of civil society, which is Public Integrity Council, and the High Qualification Commission of Judges of Ukraine more clear, because we are working for the same goal, and I don't see any reasons for a conflict. That can be changed even at the level of bylaws, to be more specific, through the changes in the regulation of the HQCJ, because now this regulation contains just a few things telling about common criteria and kind of response to the claims expressed by the PIC. It seems to me we just have one provision in the regulation, seems to me 4.10. Then, if we speak about the openness and transparency of the very procedure, openness, well, it means active openness, not just that you can be writing about us, that's okay. No, the HQCJ should explain the society what the society's task is and what it has to do. And it should even invite the best representatives to the competition. Thank you.
Professor, you were a mature adult at the time that the Soviet Union fell and Ukraine gained its independence. Was there something that Ukraine should have done better at that moment in order to assure itself a better judicial future? Is there some cleaner break with its Soviet heritage or legacy that it might have done at that time? Was there something it did differently from Eastern European nations that also shared independence at that time and that may have moved more quickly and more successfully in the direction of judicial reform?
Thank you for the question, Your Honor. Yes. I've been thinking about this, and even in the third section of my PhD thesis, I wrote about this. I think that we did not lose our chance, because the chance is still here. But I think that in 1991 or 1992, when the first legal act on the judicial reform was adopted, which was the resolution of the Parliament of Ukraine on the judicial reform, it contained almost all the tools that were required to really launch this reform and to accelerate it, to implement it quickly. But unfortunately, that document was formally adopted, but it was not used. It was not applied. And already back then, in 1992, some more radical changes and reforms could have been introduced for the judiciary. We had the Code of Commercial Procedure passed. We had legislative amendments, in particular amendments to the law on the status of judges. But the problem is that the norms and their implementation, well, there was an abyss, there was a gap between these two things, and it was not settled in any way. Then the Constitution of Ukraine was adopted in 1996. It contained a separate section, the judiciary, and fortunately, back then, at least the Constitutional Court of Ukraine was established, and it is a powerful tool, a tool that started working almost right away. Well, of course, it was introduced even before the Constitution, but it started working after the Constitution was adopted. To tell the truth, I do not support the idea that the reform was not taking place at all. It was taking place right from the beginning, after the collapse of the Soviet Union, and the results could be noticed, but it was very, very slow. Unfortunately, we failed to introduce this reform and implement it as quickly in some other post-Soviet countries, in particular the Baltic states and the Central European countries. And that must be a lesson from us to learn, for us to learn. We cannot go back to that moment of history, but we should learn the lessons and accelerate these procedures now. I'm sure that we just don't have any other way out, because besides accession to the European Union, there is no other choice. All other ways are the ways to leading us to the kind of abyss.
Let me also say that I admire your definition of the rule of law. We've seen many, many definitions and assertions concerning the rule of law and the various applications that we've had, but you're one of the very few that's emphasized the fact that the rule of law contributes to the certainty and the predictability of the law, and I agree with you. That's a very important aspect of that concept. So, thank you. Let me pass you on right now, please, to my colleague, Judge Zarzeczny.
Good morning, Mr. Smorodynskyi. Yes.
Good morning, Your Honor.
One of the areas that is a particular interest to me with respect to the judicial appointment process, which of course is the responsibility in the first instance of the High Qualification Commission, is the issue of gender equality. And I can say to you that many of the countries that we come from have the same challenge. Women represent approximately 50% of the population, more or less. We've made some progress because they now represent 50% of the students in the law faculty of our universities. However, they only represent 1/3, approximately, more or less, of the judiciary. And so there is a disproportionate involvement of women in the judiciary. And I note that in your motivation letter, sir, you do recognize this challenge, and you do address it, which was a breath of fresh air, frankly, because we have not had many candidates confront that challenging situation. So you say in your motivation letter, the principle of equality requires my colleagues and me to treat each candidate for the position of a judge impartially and unbiasedly, and not to discriminate against them on the grounds of age, gender, nationality, or race. And that, of course, is a fundamental principle that will guide the work of the High Qualification Commission of Judges. But then I think you very insightfully, sir, observe that fairness will require scrupulous adherence by my colleagues and me to the requirements for candidates and their selection process involving requirements such as legality and legal certainty. I suggest that it is the achievement of a fair balance between several important social values in solving the problem of filling 2,500 vacant judicial positions. And then we come to the sentence that I will invite you to elaborate upon. An important legal tool to address this issue should be our application of the proportionality test. And I wonder if you could expand for us not only your concept of what is the proportionality test, but how does that test apply to respond to the present gender inequality and representation of women on the court?
Thank you for this question, Your Honor. I think that this proportionality test is quite a universal tool in order to achieve fairness in any of the decisions made in any of the procedures, including the selection procedures. And here we must speak of two important values that we must consider. Number one, and it doesn't really pertain to gender equality, but that's the value of access to justice. So we need to select those 2,000 or 3,000 people according to different statistics. So we need to quickly ensure that people have access to justice by selecting these people. And the right to justice means the right to fair court. So we must have not just the number of judges filling those positions, but we must primarily find those people who are independent, competent, people with integrity, and those who have respect for human dignity. So this is the first thing that should be taken into consideration. And I think that when we conduct this test, and I believe that it's going to be the demand of the society and the state and its legislative and executive branches of the government will be requiring for the future members of the Constitutional Court to be just, and they will be requiring quality of these candidates. As far as gender equality is concerned, there should be some balance specified. We must have proportionality between the need to ensure absolute equality, equality foreseen by law, regardless of gender, age, regardless of other criteria. But at the same time, if we look at history and if we look at the current circumstances, in particular the situation with the Supreme Court, so one of the candidates already mentioned that in trial courts we have more female judges, while in the Supreme Court we have more men. The exception is the Administrative Cassation Court. So I think that we must consider the desired result for this society. We must take into account gender sensitivity and gender equality, but it must be taken into account simultaneously with other criteria after we have checked the candidates for their professional competence and integrity. And I'm talking about positive and negative integrity. So on equal grounds, we can give preference to those people who did not have those preferences before. So this is if we are talking about gender equality. So under these circumstances, we could give preference to a woman. If all the other criteria with that woman and the other candidate are equal. But again, it's important to assess independence, integrity, and competence first. Thank you, Your Honor.
Yes, thank you for your answer. A very brave answer, if I may say so. One other aspect that I would like you to expand upon is, I think, your very insightful observation that when it comes to integrity, that can be assessed both in terms of positive indicators and negative indicators. And it has often been said that you cannot prove integrity, but you can make conclusions about integrity based upon the circumstances and an absence of integrity as demonstrated by an individual's conduct and circumstances. Is there anything additional that you can provide with respect to your thoughts on the assessment of integrity?
Thank you for the question, Your Honor. So, I would like to comment on some of the statements previously made by other candidates during their interviews about the presumption of integrity or presumption of non-integrity. So, about the things that a member of HQCJ should follow when assessing the candidates. I think we should be speaking about the presumption of non-integrity. And it's nothing bad. It's not a violation of the rights of the candidate. It's a tool that must be applied by a member of HQCJ to have this doubt about integrity. And then it's for the candidate to dispel any doubts by providing proof, by providing explanations. And when a member of HQCJ sees that there is no doubt left, then they can have their idea about the integrity of the candidate. So, in my opinion, this is the criteria of the presumption of non-integrity. It's not bad. It doesn't contradict the principle of presumption of integrity as we see it in the criminal proceedings. Thank you, Your Honor.
Yes, thanks for that further explanation. I will now turn the matter over to my colleague, Judge Mizentsev.
Thank you, Ted. Доброго дня, пане Вікторе.
Good morning, Victor.
Називати мене ваша честь, тому що це процесуальне
Right at the
звернення
beginning, I would like to ask you not to address me as your honor because we are not in the courtroom. Today, I'm acting rather as an HR, not a judge, so the environment here is much more friendly and supportive than it may be in the courtroom. Since the very beginning, I would like to tell you that we are very satisfied with your answer about the presumption of integrity and non-integrity. We've been waiting for an answer like that for quite a long time. So you have provided us with quite a detailed vision about the cleansing of the judiciary and the importance of preventing corruption. You mentioned the principle of zero tolerance for corruption. But if we look at the Ukrainian corruption as something that is very negative and then add those couple of judges who have integrity, in general, we will have a negative picture. We will still have a picture of corrupt judiciary. So, could you please tell us about some specific measures that could influence the tolerance to corruption, and not just corruption in the judiciary, but within the Ukrainian society, within the Ukrainian government? Thank you. In my opinion, it is really important how people see all these processes, how the society sees all the processes. And at the moment, I do not see negative attitude towards corruption as such, towards some manifestations of corruption. Yes, people understand how corruption may affect their life, the level of their income or living, or even the security of the country. And if we provide them with these explanations, sometimes their position may change. But in general, the attitude towards corruption is rather neutral. So a person got lucky. So if somebody is corrupt, so the perception is that that person is lucky. So my suggestions on how to deal with that. Number one is to constantly talk to people, to explain to them. And I'm not seeing that we are doing that in mass media, let's say. I'm not seeing that civil society organizations or government authorities or even the HQCJ members. I think that they can do it in their interviews. In different mass media, they need to convey this message to the people that corruption is not some general factor that affects the country, that it's something that affects each of them personally. So right now, at this very moment, corruption has a negative impact on you, on the future of your children. And number two, that's something that I've already mentioned, is the positive integrity. So those people who suffer from corruption, including within courts, must be involved in active counteraction of corruption. It's not enough for you to not be corrupt yourself. Thank you. You've graduated from Yaroslav Mudry National Law Academy in 1996, right?
Яким чином ви вступили до цього закладу, який тоді звався ще Харківський
So,
юридичний інститут?
at the moment it was called Kharkiv Law Institute. So, you entered the Law Institute in 1991. Could you please clarify? Yes, I entered the institute in 1991. Yes, thank you for the clarification. So I entered the same institute in 1992, and it was the first year when they accepted somebody who was not a member of the Communist Party or a candidate to become a member of the Communist paper. And it is seen from your motivational letter that you were a member of the Communist Party between the years 1990 and 1991. So could you please tell us, you joining the Communist Party in 1990 was stipulated by the fact that you wanted to enter law school in Kharkiv, or was it because you shared some of the ideas of the Communist Party? Could you explain the motivation for joining the party? Thank you for this question. First of all, I joined the party in the year 1990, and at the time, I did not dream about becoming a student of the Kharkiv Law Institute. I was a student of the aviation vocational school, and I saw my future within that profession. I wanted to become an aviation engineer. I was a part-time student, and I was a student of the Faculty of Engine Building. But in the year 1990, when I was already graduating from Kharkiv Aviation Institute, I saw real democratic transformations, the transformations supported by Western countries. And we had that conference take place where Professor Alexeyev was elected the first head of the Committee for Constitutional Oversight. We saw democratization happening via the actions of Mr. Gorbachev even. So I did not dream about entering the law university, but my question was not about that. I'm asking you whether you shared the ideas of the Communist Party, or did you use your membership in the party as a way to get a promotion somehow, a professional promotion? Thank you for this question. I have already answered this question in writing. Yes, but we would like to hear your explanation once again for the audience to hear it. I was sharing the democratic changes, the democratic direction. but somehow it correlated with that democratic wing of the Communist Party that I joined. And I joined the Communist Party under the recommendation of the Brigade of Mechanics of the Aviation Vocational School, from which I graduated. And they provided me with that recommendation. They believed that I was one of the best aviation engineers. And it was a token of their respect for my professional achievements. Thank you, Viktor. That's clear. And towards the end, I have this question for you. In the year 2001, your wife bought an apartment in the city of Kharkiv with the area of 112 square meters for almost 16,000 hryvnias at the time, which in US dollars equaled 3,200, which for an apartment of 112 square meters is not a very typical price. Could you please explain what stipulated this price? Thank you for the question. I have already provided my explanations. At the moment, the apartment was bought by my wife at a time when we were not yet married. She just got divorced from her previous husband when she was buying that apartment, so I'm in no way involved in the purchase of that apartment. So I'm not the co-owner, I've never been a co-owner, and I'm not going to become a co-owner. Yes, but when did you get married? In the year 2002. Thank you, thank you. Now it's all clear. I'm now passing the floor to my colleague, Mr. Verlanov. Good morning, Viktor. As a follow-up question, with regards to the application of presumption of non-integrity when assessing the candidates, I would like to ask you the following. Do we need to assess zero tolerance of a candidate or a judge towards the integrity of other colleagues? Thank you for the question. Yes, of course. If we have some evidence contained in documents, I see the role of PIC in all of this. The PIC, which can use tools that the HQCJ does not have. And I mean that they have information not just about the behavior of the candidate as proven by different documents, but they can also acquire information from other sources. And I think that on the level of qualification assessment, an interview also plays an important role, because during interviews we can ask different questions. Moreover, I understand that after 3 or 4 questions, all the other candidates who are watching the broadcasts, who are listening to the broadcasts, they will get an idea of how they should answer the questions. It's not bad. They will have an idea of what positive integrity is. They will understand that they need to have dignity for themselves, and they need to have zero tolerance for non-integrity of their colleagues or other members of their professional community. And of course, we need to talk about intuition, the intuition of the interviewer, who is a member of HQCJ. And this intuition must be rooted in their experience, not just professional experience, but the overall life experience. Thank you, Viktor, for the answer. And in your professional life, have you ever used this intuition? Thank you for the question. Yes, I've been doing it for 4 years already as a head of the Commission for Academic Integrity at our university. During the first year, we only considered cases on the appeals of students and teachers, but when we proved that we were efficient, we were able to enhance trust and understanding of what integrity was at our university, and those are not just empty words and phrases. I'm really proud of what we've accomplished. So I personally asked our scholarly council and the rector to introduce changes to the regulations and expand our mandate so that we could conduct monitoring of integrity within our academic community. And definitely, intuition plays an important role when making final decisions about integrity or lack thereof. And we are talking about integrity both of students and teachers of our university. And we've made difficult decisions, but we've practically not made any mistakes. So could you please finish? So what was the result? The result is that based on our decisions over the most recent period, some of our teachers were let go because they lacked integrity. 2 students were expelled. But that's even not the most important thing. The most important thing is that we've enhanced understanding of what integrity is, and we have negative attitude towards lack of integrity on the part of students in particular. They are no longer afraid to address us, to file their complaints. And how did you highlight or cover these examples within your university so that everybody knew about those cases of non-integrity? So we have a web page, and in the motivational letter I provided a link to that web page. And there you can find the code of academic ethics. And we were involved in the development of the new version of this code. We have the regulations on academic integrity, and there you can find all of our most recent decisions made by the most recent composition of our commission. And also you can find other documents there, not just the decisions, and also the most recent ones are those put out of the website since the beginning of the full-scale invasion. So thank you, that's clear. So you think that you made a positive change within your university? Yes, I see it, and it's obvious for me that it's been a positive change. Yes, thank you, Viktor. And in your motivational letter, you also said that an independent, powerful, and efficient judiciary is good for any state and government. So we need to turn down the strength of power in favor of the rule of law. So maybe could you clarify that a little bit? So do you mean that the judiciary must not be part of the government, or did you mean something else? Thank you for the question. The judiciary is an independent branch of the government, according to the principle under which we have 3 branches of government, where we have the mechanism of checks and balances. When we are talking about government, we mean 2 things. The 2 other branches of government, the executive government, first of all, which can exert its pressure upon the two other branches, including the judiciary. And it's something that we can see not just in Ukraine, which is a young democracy, but also in other countries with a more established tradition. And researchers and academics have pointed out to that in different papers written by them. Nobody is denying the need for self-restraint, and that's something that Professor Shayo, a judge of the European Court for Human Rights from Hungary, he talked about self-restraint. He said that the judiciary should have that self-restraint and keep itself from abusing the power, from abusing its position. And we can see it on the example of the Ukrainian judiciary, and we are all well aware of what the situation in the judiciary is. Thank you. Thank you, Viktor. I have no other questions for you, and I'm passing the floor to our chair.
Дякую, пане Сергію. Чи будуть ще
Thank you,
запитання?
Sergei. Do we have any additional questions for our candidate?
Пане Вікторе,
No, there are none.
наша співбесіда добігає кінця.
Victor, our interview is coming to an end.
Будь ласка, у своєму фінальному слові, що б ви хотіли сказати?
You will now have time for some concluding remarks. What would you like to tell the commissioners and the audience based on your today's interview? Thank you. Thank you, Mr. Chair. I didn't have enough time to tell you everything, but within the different courses that I study at the university, I always tell everybody about my favorite decision. So the Committee Against Torturing versus the State of Israel, and the rapporteur judge in that case said that judges do not stay in ivory towers. We are members of this society, and we have our path, the path of truth and law, and we must follow this path. I'm sure that those judges that will be selected by the HQCJ will take this path. And I would like to thank the Commission for establishing clear rules and for following them, for the certainty. And I'm sure that all the candidates who will become members of HQCJ will see the need and importance to have this kind of certainty. That's the rule of law with regards to any selection, and I hope that they will be implementing that. So I'm calling this an unbreakable law, an unbreakable chain of the rule of law. Thank you.
Дякуємо вам, пане Вікторе.
Thank you, Victor.
Наша співбесіда завершена.
Our interview has come to an end. Thank you for participation. All the best to you. Take care and goodbye. Thank you. Goodbye.